What were you drinking then?
Twisted tea, Your Honor.
You just are continuing to consume alcohol. Quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
My point in that is he's highly intoxicated during these films. So that's certainly a concern if he were to be released even on a scram tether.
If this defendant really showed up to court thinking he could outsmart the entire justice system with a few weak explanations about his drug tests. It's honestly wild how some people treat a court hearing like it's optional homework, especially when they're already wrapped up in a serious criminal case. In this clip, the prosecutor barely has to lift a finger. The facts speak so loudly that it's hard to understand how this guy was even walking free to begin with. He's like that one friend who gets caught red-handed and still insists they did nothing wrong, even though everyone knows exactly what happened. Let me know in the comments if you think people like this deserve another chance on bond, or if zero tolerance is the only way to keep courtrooms from turning into a joke. Let's get into it.
Hey, Dustin, just state your name for the record, please.
Dustin Duncan.
All right, Your Honor, thank you for recalling this matter. So based on Mr. Duncan's appearance, I would ask the court to withdraw the bench warrant.
What was his name?
There's a bond violation.
Yeah, no, I see it. Well, you see the violation. The violation was the reason that I issued the warrant in this case.
Right, Your Honor. I've discussed the bond violation with Mr. Duncan. And Your Honor, to his credit, he did contact his community corrections agent and admitted.
When did he do that?
To consuming alcohol. The report indicates that he did, or it may have been the email actually that was sent out by Mr. Casey, where it indicated that Mr. Duncan did call him and admitted to drinking a twisted tea on September 13th, which is what ultimately led to the positive test on that date. And then obviously we do have other issues. I'm aware of that, but at least he did admit to consuming alcohol to his community corrections agent. I can tell you that based on my discussion with Mr. Duncan, he has started attending some meetings with the Alano Club. He has reached out to Home of New Vision. He's an admitted alcoholic, Your Honor.
You wrote Pickett.
I understand all of that, but my other problem is that given the other sort of mistest, I mean, what about on, you say the twisted tea on the 13th, what about on August 30th? What were you drinking then?
Same twisted tea, Your Honor. I've contacted Home and New Vision. Can I speak?
Well, I just said that, but you're welcome to say it if you'd like to.
No, I didn't. Contacted Mr. Leroy Pickett with Home and New Vision for a sponsor. I had 4 years clean and I relapsed. I know firsthand I need help with it.
Well, I understand all of that, sir, but so here's part of the problem that I'm having. Not only is there then these tests, he also has then missed tests, of which I would have to assume you're drinking.
Yes, I was.
So I'm going to ask you this, all right?
Okay.
I have a bunch of missed tests. But on August 30th, I have the alcohol shows up. On September 13th, alcohol shows up. And we have more missed tests. So between, I guess, the 16th, the date of this report, and the date you went on the tether back in August, how many times have you drank?
6 or 7, maybe
Yeah.
8. I had 2 missed tests. I was in the hospital, but I did. Yes, I did.
You just are continuing to consume alcohol. And you're playing with the testing so that it appears as though it's just a missed test, when in fact, what it is you're drinking. Quite frankly, need to go inpatient. I mean, you know you can't do this on your own.
Correct, sir.
Mr. Bowling.
Your Honor, Mr. Duncan is the sole care provider for his 95-year-old mother. I don't necessarily disagree with what this court just stated, and I don't think Mr. Duncan does either. Would the court consider allowing him to be put onto a scram tether?
The moment the prosecutor brings up that he was out in traffic swinging a knife around, the entire sympathy story completely falls apart. You cannot stand in front of a judge talking about just one drink when your actual behavior could have seriously hurt, or even killed, someone. This is the kind of conduct that gets people locked up on the spot, yet somehow he still thought asking for a tether was a reasonable option. You can tell the judge is done with the minimizing. He stops even pretending to entertain the excuses. The defense attorney is clearly just doing his job, trying to soften the situation, but some cases simply cannot be sugarcoated no matter how hard you try. Watching the defendant slowly realize that his whole sobriety narrative is collapsing is honestly tough to watch. I know there are always people in the comments who argue that guys like this deserve another chance, so if that's you, explain why, because I see that defense on almost every video. Alright, let's jump back in.
The reality is, in this type of circumstance, that doesn't help.
If nothing else, maybe it would be a reminder with a device on his leg that maybe he needs to call a sponsor if he feels like he needs to drink, or that he needs to attend an online AA meeting at any time of the day. Maybe the tether on his body would give a little bit more reminder than the SoberLink sitting on the nightstand table or the couch side table.
People have some concerns if you'd like to hear.
Yes, go on.
Well, the allegations include that Mr. Duncan was highly intoxicated at the time, walking into traffic, wielding a knife, trying to punch cars, making statements to incite a fight, continued that type of behavior when police arrived to take him into custody. My point in that is he was highly intoxicated during these felonies. So that's certainly a concern if he were to be released, even on a scram tether. At most, I would think the court could maybe consider a release to long-term inpatient treatment if you were to take him into custody. Thank you.
To adjourn the defendant's probable cause conference to September 30th, 2025, 9 a.m. And at this time, given the violations, defendant's body. Thank you.
The court adjourns the defendant's probable cause conference to September 30th, 2025, at 9 a.m., and based on the violations, the bond decision is made. This hearing is a perfect example of how quickly things can turn in a courtroom. Addiction is real, but once someone starts putting the public at risk, the judge has no real choice but to step in and take away their freedom. You'd be surprised how many people end up back in custody simply because they refuse to be honest about a slip-up before it spirals into something much worse. In this case, the judge did exactly what the law expects. Protect the community first, feelings second. It's hard to feel sympathy when the defendant kept pushing his luck until there was nothing left to argue. Watching him get remanded that fast should be a wake-up call to anyone who treats bond conditions like suggestions. So what do you think? Did the judge handle this fairly, or would you have given him one last chance to prove himself? Thanks for watching, guys. Make sure to like and subscribe, and we'll see you next time.